Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers, where I challenge you to replace a 10th of an hour of billing with a 10th of an hour of learning. For this episode 18, it's hard to do this subject justice in just a 10th of an hour, but I'm going to highlight some key points in a recent Colorado case that really bring this issue to light. And our theme for today is to be careful with beneficiary designations and joint tenancy. This is a presentation geared towards wealth professionals, but if you're a potential client listening, this should also serve as a cautionary tale to check your asset titling and beneficiary designations. Now, a lot of people assume that when they get an estate plan put in place and execute a will and/or a revocable trust, that these documents are effective to dispose of all of their assets at death. However, it's important to note, and very few people really recognize this, that any beneficiary designations on assets or accounts will supersede the terms of your will and any trust you have unless your estate or the trust or a testamentary trust under your will are named as beneficiaries. And similarly, if you title assets as joint tenants with a spouse or child or somebody else, the asset will go to the surviving joint tenants instead of passing under your will or trust unless you yourself are the surviving joint tenant. So beneficiary designations and joint tenancy titling can override your entire estate plan no matter how good it is and how many thousands or hundreds of dollars you spend getting it in place. And it's important to note that when you're dealing with financial assets, the online account forms and call centers at many financial institutions are now prompting for a beneficiary when you deal with the account. Now, this is a pet peeve of mine, and many clients do not understand the significance of adding a beneficiary to an account like this, but it can completely torpedo your estate plan and cause immense expense and tax liability to your estate and to your heirs and beneficiaries. Now, where are beneficiary designations found? Well, the most obvious sources usually are life insurance and retirement accounts and annuities. But importantly, going back to my point on accounts and online servicing and call center servicing, when you have taxable financial accounts, you can name a beneficiary on those as well. Now, this is specifically called a payable on death or transfer on death designation, a POD or TOD, but a lot of financial institutions misname it and call it adding a beneficiary onto that account. Now, any beneficiary designations in these categories that are inconsistent with your estate plan can cause unnecessary litigation and create additional estate tax, generation skipping transfer tax, and income tax liabilities. And as we're about to look at too, they can also affect a beneficiary's eligibility for government benefits. So it's important also to look at the many layers of this. You need to consider not only your primary beneficiary on these accounts, but also any contingent beneficiaries as well. What if, say, you and your spouse both die? Then that asset could go to contingent beneficiaries. What if you don't have any contingent beneficiaries? Well, in some things like life insurance and retirement accounts, then that asset can by default, instead of going to your estate, maybe go to distant family members. All of these can cause huge issues. So, especially in the case of minor or disabled beneficiaries, when they are named as a beneficiary on a financial account, most financial institutions are now requiring a full-blown conservatorship as a condition to paying out on that account or retirement plan or whatever the case might be. A custodial account for a minor is not enough in any of these cases. And there was a recent Colorado Court of Appeals opinion in Ray Black which brought this to light. And in this case, there was a disabled beneficiary, and the mother of this beneficiary had created a special needs trust under her will to be established for the disabled daughter. And that's important. You have to have a special needs trust in place to protect the daughter's eligibility for means-tested government benefits like Medicaid and SSI. However, the mother then, after creating her will, added a POD designation onto a financial account of $3 million, which would cause that account to get paid directly to the disabled beneficiary upon death instead of routing it through this special needs trust. So that's a problem in and of itself because it instantly blows that disabled beneficiary's eligibility for any government benefits and would terminate any benefits that they are then receiving at the time of payout. So because of this, a conservatorship was required, and years of costly litigation and jurisdictional battles ensued when the conservator, who was also the trustee of the Special Needs Trust, ended up misusing the POD funds that were routed to the trust through a disclaimer that the conservator executed on the disabled beneficiary's behalf. So, that disclaimer itself was a well-intentioned act because the disclaimer could protect the disabled beneficiary's eligibility for government benefits by routing those assets into the Special Needs Trust. But the use of the funds in the trust and all sorts of acts that happened after that caused all sorts of issues, and really what set off this firestorm is that the disabled beneficiary contested that she was not informed of the effect of this disclaimer. So a simple act of just not letting her know what's going on and allowing her to make her own choice led to years of litigation and millions of dollars in legal fees, all of which could have been avoided if there had not been this POD designation added on to a financial account. So the stories out there are many, but this is just one of many cautionary tales. So some key takeaways are that obviously life insurance and retirement accounts should have beneficiary designations which align with the estate plan, and in the case of retirement accounts, which align with the tax deferral permitted under the Secure Act, which was recently passed at the end of 2019. However, it's also important to note that increasingly banks and financial institutions are requesting a beneficiary on taxable accounts themselves. And that's bad, and that was the issue in the Black opinion. And it's also important to note that minor children aren't given as much thought as they should under an estate plan. And there's two things that are vital. One, obviously, as we discussed back in episode 13, is naming a guardian and conservator for a child who can serve if both parents are disabled or incapacitated. But even if one parent is living and you name a child as a beneficiary under an account, that's not going to take away the need for a conservatorship potentially. So another strategy is to create separate trusts for children, which are funded at the death of the account owner, which can help avoid conservatorships and can last at least until the child reaches the age of majority, so that you don't need this expensive court intervention to simply pay the inheritance to a child. And importantly, you have to name these trusts and not the children as beneficiaries on the various accounts we discussed. That's it for today's episode of the 10th of an Hour. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode, and I look forward to seeing you in the next one.